In other legal stories, dispute resolution in the Nigerian capital market is still one issue agitating the minds of lawyers, judges, lawmakers, accountants, stockbrokers, and other members of the capital market community.
This girl you're talking about is also your sister.
The Capital Market Solicitors Association at this forum, chaired by retired Justice Adeshola Oguntade, hosted a vibrant crowd of participants who discussed the jurisdictional issues involving the Federal High Court and the Investment and Securities Tribunal (IST). They dissected the problems and, of course, gave robust and varied solutions.
As of today, for those of us that are in practice, you still have to make the decision as to which court you want to approach. You have an issue of choice of jurisdiction. And recently, in our own firm, we are dealing with a case right now that had to do with directors who gave themselves some jumbo bonuses immediately after they raised 5 billion. I think we need to do a comprehensive rethink of the structure. I think perhaps instead of IST coming here to tell us how much they've achieved and all the cases that they've decided, they should recognize that this problem is out there and practitioners are facing it, and they should be more proactive in how they engage the process. And what I mean is how they engage us as practitioners and how they engage the Federal High Court. One concept they can consider is the idea of mutual cooperation between them and the Federal High Court. Perhaps they can consider some of the concepts that have worked very well in other systems, like setting up a users forum or council, and then there will be some forum where the Federal High Court judges and the IST members meet, and then they meet with us as practitioners to discuss how we can, either through rulemaking and other schemes, prevent what I would call the jurisdictional bleeding that is going on.
Chief Idigwe has suggested some administrative solutions. And I think in many countries, if I looked at this, if I were in England and someone said, if you have this type of problem, what's the answer likely to be? I think the answer is likely to be administrative or very subsidiary legislation. Someone would come and pass some regulations allocating and clarifying jurisdiction between the IST and the Federal High Court. The idea that you have to litigate for 10 or 12 years, all the way to the Supreme Court, just to be told in which court you should issue your proceeding, is a disgrace. And I think it's an indictment on the system that wastes people's time and resources. It may be a game for lawyers, it may be enriching, but it does the system no good or service at all. But unless you also amend the Constitution so as to ensure that these conflicts don't arise, I don't see that the problem is going to go away.
I've done a bit of historical research into this, and I realized that what gave rise to the problem is, I'd say with respect, a somewhat cavalier attitude to legislation. And I think this comes out also from what the chairman has said. And I've had cause to say this on various other occasions. I don't see any reason why the legislature would embark on passing a law that has to do with the creation of a court or the judiciary as a whole without involving those who will operate that system. It is when things like that happen that you have this kind of problems, because it's quite obvious that the things that Chief Idigwe and Professor Odita have spoken about informal fora, the Federal High Court judges sitting with the IST members to try and resolve areas of conflict, are things that should have taken place before the law was passed, not after the event. I mean, that's why in other advanced democracies, you hear of legislation going through about 2 years of reviews, white papers, green papers, all sorts of colored papers, before they arrive at what would generally be a consensus. So the operators of the system, the judges, the members of the IST would have already identified and addressed these issues before the law was passed. But here, we consistently play catch-up, and we have these kind of problems.
What of the people who have invested their money in the capital market and then are unable, on the basis of someone's, some companies' misbehavior on the market or market manipulation, now lack the right to recover the monies that they had invested in the market, only because the law is not clear? I think the best way forward would be a constitutional amendment. It will put it to rest. One final proposition that I want to put forward as a solution is that perhaps we should have a judicial stakeholders meeting where both the judiciary, the Ministry of Justice, as well as the bar will sit down and say to ourselves, what is the correct hierarchy that we should adopt in terms of our courts? Because if we do it, first of all, it will remove the possibility or the need to create further courts, and then it will probably allow us deal with the more structural issue, which is the way our courts are presently provided with infrastructure and manpower. I don't see why, for instance, we should not have, for justices of the Court of Appeal, justices of the Supreme Court, judges of the High Court, a clerking system whereby judges in the judiciary can have access to the finest legal minds to prefer adequate solutions and reduce their workload, allow them to deal with the real issues.
There is no doubt that we have serious problems in the country concerning congestion in all the courts, and it's indeed comforting to know that the IST has been doing very well in terms of the speed with which that body disposes of cases. If not for this problem we are having with appeals and the contention prevailing, that body is not suitable to adjudicate at that level, I would have said, why don't you leave them alone? At least they're doing something. But as it is, they are also creating a bottleneck because of appeals being filed from their decisions to the different appellate courts.
Another group of discussants at the session, chaired by former Attorney General of the Federation, Chief Bayo Ojo, threw up non-litigation mechanisms for resolving capital market disputes.
If the necessary framework is developed for ADR, for capital market issues, once there are issues, you just go that way straight. You understand what I'm saying? Either by way of arbitration or by way of mediation. And then whatever decision is arrived at will be binding on the parties. Because if you mediate, at the end of the mediation, you sign a mediation agreement. If you arbitrate, at the end of the day, you'll get an award, which is not appealable. You can only challenge it for misconduct.
What we are now going to do is to go through these suggestions and then make a distillation out of them. If a committee comes out of it, well, all well and good. Otherwise, we should be able to say, look at the opinions. And then we'll now transmit that to the policymakers to have a look at what the community is saying, the legal community as well as the capital market community is saying. I think the most important thing, message to take home is that people really don't want us to wait year after year until there's an ultimate decision of the Apex Court resolving this matter. We thought that the policymakers can intervene at this period and then find a way to resolve this matter. A quicker resolution will serve the market well because the transaction solicitors are finding it difficult to render opinions to the foreign clients who keep asking what are the dispute resolution mechanisms, which court has jurisdiction to determine on a capital market transaction.